existing non-compete agreements with pretty much all of the workers, they cannot be enforced. And no new non-compete agreements can be created for all workers, and that includes senior execs. And if a non-compete is unenforceable, no individual who has worked for another party in any capacity, again, whether they're a paid or unpaid employee, contractor, intern, they cannot be prevented. They can be prevented from working for someone else or start their own business. Also important to note that this ban does not apply to franchisees like owners of chain restaurants and for certain nonprofit.
You're listening to the Black to Business Podcast, an educational podcast providing Black entrepreneurs with the tools and resources to start and grow their businesses. We chat with vetted Black entrepreneurs, thought leaders, and business owners as they provide tips and resources to help take your business to the next level. I'm your host, Merlyne Jean-Louis. Hey, welcome back to another episode of the Black to Business Podcast. It's your favorite host, Monique T. Marshall, and today we are getting into some super important stuff that every entrepreneur needs to hear about, and it doesn't matter which industry you are in. So in today's episode, we're actually talking about two big new regulations, the FTC Non-compete Rule and the Corporate Transparency Act, because they have some real life impacts on how we run our business and move forward in our careers. So it's so good because I recently actually attended an incredible workshop held by our guest today, the phenomenal Merlyne Jean-Louis. And I was absolutely blown away by how much I learned during the workshop. And I thought to myself, y'all, we have to have Merlyne on the show. And so guess what? She graciously agreed, and trust me, you are in for a treat. Now, before we dive in, let me give you a little background about our guest today. Merlyne Jean-Louis is an absolute powerhouse in the legal world. She's the founder of Jean-Louis Law, a bi-coastal virtual law firm that focuses on business and entertainment law. She's a proud graduate of Duke Law and NYU. She helps creatives, including influencers, podcasters, and filmmakers and businesses all over the nation protect their ABCs, assets, brand, and content via contracts, trademarks, copyright, and business structure. She truly knows her stuff. And she's also a legal commentator and has been featured on Bloomberg, CBS, The Verge, and Fast Company. So today, Merlyne's going to break down everything. I'm talking about FTC's non-compete rule that's going to change how we think about job mobility, and the Corporate Transparency Act aimed at making business operations more straightforward and honest. So this is going to be a masterclass conversation for sure because Merlyne is breaking it down. She's giving us the definitions, examples, and I must stress that this is not advice. We do want to give a disclaimer that after this conversation or during this conversation, it is still important that you seek legal counsel always. So grab a notebook or open up your notes app because you're going to want to jot all these things down. So let's dive in. To the Black to Business Podcast. I'm excited to have you on the show because I recently attended one of your workshops and I was like, we got to have her on the show. So welcome to the show.
Thank you, Monique, for having me. I appreciate it.
Yes. So before we get into all this nitty gritty, because we have a lot to cover today, I would love for you to tell the people a little bit about your background, your business journey, and how you got where you are today.
Oh, that's a good question. I am a business entertainment lawyer. I like to say that I help all kinds of businesses and creatives and entrepreneurs protect their ABCs, their assets, brand, and content via contracts, trademarks, copyright, and business structure. So my journey to start my own business was not something I foresaw. I didn't think that's going to happen for me. I started law school at the tail end of the Great Recession, and if you don't know how law school works, basically you're hired for your full-time job after law school, after your first year of law school. And it was a rough time. Firms were not hiring as much as they were. And so I was not able to get into the law firm, big law funnel. And so I started my law firm 3 years after graduating from law school because I couldn't get a job. I couldn't get like a job at a law firm or a job in-house. And so I taught myself how to basically practice the law and run a law firm business. And so that is what my business journey. And I started my law firm about 9 years ago.
Mm. Talk about forging your own path.
Yes.
That is a
Yes.
lot and good. How was that?
It was interesting. Like, you said, your audience is like first generation. I'm first generation as well. My parents come from Haiti. Like, it was interesting because I didn't really know how to navigate. I had to figure it out sometimes, but I also had to rely on some peers of mine who were going through the same things as well.
Mm-hmm. I know a lot of people can relate to that, all the things. And I'm so glad that you struck out on your own because, as I mentioned before, where I first heard your presentation, it was all about what we're talking about today. So really the topic is understanding the impact of the FTC Non-compete Rule and Corporate Transparency Act. So when I first saw the workshop come up, I'm like, what is this all about? It's something that I need to know. Then I attended the workshop. I'm like, okay, this is something the Black to Business family needs to know. So I'm so excited to dive in. So somebody might be listening like, what is this all about, Monique? I'm like you were. So we're going to get into the movie and start with the basics. So understanding the FTC non-compete rule. So what is the FTC non-compete rule and why was it introduced?
Right. Good question. So the FTC, the Federal Trade Commission, it's an agency that basically enforces, there's a law called the Federal Trade Commission Act, and it battles, it prevents anti-competition. So the FTC is charged to create rules and regulations to prevent anti-competition. And so this rulemaking process for this particular rule, the non-compete rule, started the beginning of last year. And they put out a preliminary rule, a proposed rule, and then anyone in the nation can comment on the rule, provide their commentary, provide their insights, and then the FTC creates a final rule. So April of this year, 2024, is when the FTC promulgated their final rule. And it's called the non-compete rule, non-compete clause rule, essentially.
And so how does this aim to protect businesses and employees?
So the purpose, there's sort of a fourfold purpose of this rule. Number one, it's to promote competition by banning non-competes nationwide. Two, to protect workers' freedom to change their jobs. Three, to increase innovation. And lastly, to foster new business formations.
So what is the non-compete clause under this new rule?
Yeah, so I think it makes sense for me to talk about what this ban does, right? So essentially, after the rule's effective date, which is going to be September 4th, 2024. I'm a Beyonce fan, so I know 9481 is her birthday. So if you're like that, on September 4th of this year is when it goes to effect. And when that particular rule goes into effect, there's going to be a complete ban on new non-competes with all workers, including senior execs. Don't worry, I'm going to define this. So we're going to break it down. So number going to be one, a complete ban on new non-competes with all workers, including senior executives. Two, existing non-competes with workers who are not senior executives will be unenforceable. And three, existing non-competes with senior executives can remain in force. So that requires me to sort of break down what those things mean, right? What is a non-compete? What's a worker? And what's a senior exec? Because it makes sense for you to know that. So the rule defines a non-compete clause as a term or condition that either prohibits a worker from, penalizes a worker for, or functions to prevent a worker from, one, seeking or accepting work in the United States with a different person, where that work would begin after the conclusion of the employment. That includes a term and condition. Or two, operating a business in the United States after the conclusion of the employment that includes a term or condition. Like, what does that mean? So basically, it's preventing you from working for someone else after you have worked for that person. And, the definitions are defined very broadly that it includes, the term worker includes someone who is an employee, an independent contractor, extern, intern, volunteer, anyone who works for someone else, right? Employment doesn't mean employment in the traditional sense. It just means you're working for a person, and a person is anyone. It's a person, it's a corporation, entity, it's anything. So it's very broad of how this is done, right? And it can also be verbal, right? It doesn't have to be a written contract as well. And so this rule is defining these things very broadly to provide the most broad protection regarding this.
That is really broken down.
Yeah, and one more thing, senior executives, right? Because there is some exceptions for them. Senior executives there are workers who earn more than about 151K, who are in a policy making position. So they have to earn more than 151K, and they're in a policy making position. So, for example, great example of this is a CEO of a corporation. They're making a certain amount of money, but they're also in a position to make policy for that company as well. Yeah.
Wow. Okay, that was great, and that was a lot, and you really broke it down, because I know people are thinking, okay, I work with freelancers, contractors, like all of these things, especially if they're just starting out. So how do you think, like looking at the grand scheme of things, how do these agreements impact employees and businesses differently?
It's a good question. So a very common type of non-compete clause that I've heard about relates to traditional sense, employment sense, doctors. For a lot of doctors are held to non-compete clauses where they can't work for a nearby hospital within, let's say, a 50-mile radius for a matter of time, for 5 years or so. And so that's something I've seen a lot of. And when it comes to, like, I guess, service businesses, or, if let's say you work for a company, but you want to start your own business that's in a similar space. Like, it's like you work for a big company like Facebook or TikTok, and you're an engineer. And perhaps in your employment agreement, there's a clause that prevents you from working for a competitor for a certain amount of time after you have left that particular company. Those types of clauses now are going to be unenforceable. If you have that clause in your particular agreement, it's going to be unenforceable as of September 4th. So if you're working for a nonprofit, the rules are a little different, right? Because the FTC Act, the one I mentioned at the beginning, does not apply to actual nonprofits. And I know that some, corporations have a nonprofit and tax exempt status, but it doesn't mean that necessarily they're going to fall outside the jurisdiction of the FTC. So it's a very fact intensive analysis. If you want a nonprofit business, you have to basically assess this particular application of the FTC rule in your case. And number two, let me just give a summary. Let me just give a quick summary again, because I said a lot, right? So if I to summarize this, as for September 4th of 2024, existing non-compete agreements with senior executives, like CEOs, can still be enforced. Existing non-compete agreements with pretty much all of the workers, they cannot be enforced. And no new non-compete agreements can be created for all workers, and that includes senior execs. And if a non-compete is unenforceable, no individual who has worked for another party in any capacity, again, whether they're a paid or unpaid employee, contractor, intern, they cannot be prevented. They can be prevented from working for someone else or start their own business. Also important to note that this ban does not apply to franchisees, like owners of chain restaurants and for certain nonprofits. And so that's a summary. That's a quick summary of what I just said.
That's so good. All right. We are getting to work, so we are going to be ready and prepared by September 4th. So
yes.
So getting into, we want to make sure that we stay compliant. The Black to Business family stays compliant. So let's get into some steps for compliance. So what should small business owners do to ensure that they comply with these rules?
Right, because if you are a small business owner and your agreements with your workers have non-compete clauses in them, you're going to have to actually provide notice to the workers who are affected by the non-compete clauses by the date, the effective date. And so it makes sense for you to engage an employment attorney or a business attorney to determine whether your agreements contain that, and then they'll provide the next steps of notice. Like they'll probably give you a notice of what you can say to those particular workers who are affected. And if you're on the other end, right, let's say you are working for someone, but you're working on your business on the side, or you want to start your business on the side, then you want to maybe engage an attorney to determine whether your agreement now that you're engaged in has a non-compete clause, right? Because I don't know if all businesses are actually going to comply and provide notice to workers. And so whether you're a worker or you're a business, it's probably a good idea for you to work with an attorney to help determine whether the agreements you have entered into contain non-competes.
And that was a little bit around my next question. Are there any resources available to help entrepreneurs understand and implement these changes?
I mean, the FTC rule, it's there. It's available online. It's 570 pages, though. Oh. It's really long. I read it. I read the entire thing. I actually used to work at the FTC during law school. And so this is the insight I'm giving you as well from my perspective, being a former employee of that place. Like, it's a long rule. It's a long rule. So I think the summary I gave you is really good. You can go ahead and free to look up the rule itself. I'd say also, too, resources. You may want to actually set a Google alert about the FTC non-compete ban to see if there are any changes, any enforcement, or any updates in the rule itself.
Great advice. And so knowing this,
not advice. It's just information. I'd like to say that. I'll say it at the beginning. I'm providing information, not advice.
All right, that's a great point.
Yes.
We got to put a disclaimer.
Yes, we do. Yes, we do.
I have to leave that in there because that is funny. Knowing what we know, what are some, like, moving forward, what are some considerations that now business owners should keep in mind when they're drafting contracts, especially with independent contractors and freelancers?
Yeah, I mean, I don't know if many businesses prevent other people from working with other people. I don't know if that's the case. And again, this rule applies after the term has ended. Services have been provided. So, I mean, essentially, you cannot do that anymore. You cannot prevent other people from working for other competitors after they work for you. It's just something that cannot be done.
Yeah. All right. So we've gotten a lot covered so far. So let's move into Corporate Transparency Act.
Yes.
So what is the Corporate Transparency Act and why is it important for businesses?
Okay. This is a new law that was enacted. The effective date was this year, January 1st, 2024. It's actually a rule, an act that is enforced by the Department of Treasury. So the IRS, like all that people, like that's like same department, same. It's specifically the Financial Crimes Enforcement Network, otherwise known as FinCEN, that's going to be enforcing this rule. So it's a law that requires businesses, whether you're an LLC, corporation, trust, if your business has been registered or formed in the United States, you need to provide information to the Department of Treasury. And in its essence, it's going to affect the 30 million businesses that already exist and the nearly 4 million businesses that are formed every year. I think it also makes sense to know about the purpose, like why was this enacted? The CTA was enacted, number one, to prevent the misuse of U.S. entities for criminal purposes, and to help law enforcement identify and prevent the criminal activity, like, for example, money laundering or terrorist activities. Like this is the reason that they are enacted this. They enacted the rule.
Got it. Okay, we know the background. We know why things are the way they are. I love this. And now knowing, so what are the key requirements businesses need to know about?
Sure. Okay, so I have to provide more definitions.
Okay. You like definitions?
More definitions. All right. There are basically three things you need to know. Three definitions you need to know about. You need to know what reporting companies are, what beneficial owners are, and what company applicants are. Reporting companies, beneficial owners, and company applicants. Okay. So let's go with reporting companies first. So under the CTA, reporting companies are defined as domestic entities like LLCs and corporations that they are created by filing paperwork with a U.S. Secretary of State or similar office. I know some states call their office Department of State. So I know different states are called differently. And entities that are formed in countries outside the United States that are registered in the United States by filing paperwork with the Secretary of State or similar office. You know, for example, like what's a very famous international company that's formed? Louis Vuitton, right? In France, right? All Dolce & Gabbana in Italy, you know, they have businesses that are registered in the United States. So this will also apply to them as well. Okay. And so that's what a reporting company is. Beneficial owner is an individual who either one, owns or controls at least 25% of the reporting company, or two, exercises substantial control over a reporting company. So, first example of someone who's a beneficial owner, like if you are a shareholder in a corporation and you own more than 25% of the corporation, yes. But also, if you're a CEO of a corporation, you exercise substantial control over the reporting companies as well. It's important to note that some exemptions may apply, but basically, in essence, you have to provide information about beneficial owners. Okay. And company applicants. So a company applicant is, according to the CTA, it includes individuals who follow the paperwork to register or create an entity. Like, for example, like lawyers, accountants, and those who direct the filing, right? Let's say you hire a lawyer and you tell them to file paperwork. You're considered to be a company applicant as well. So what is the requirement? The requirement requires you to file a report with FinCEN that's called Beneficial Ownership Report, or a BOI report. In this report, you have to provide information about the reporting company, information about beneficial owners, and information about company advocates to some extent. There are some caveats that I'm going to discuss later, but that's generally what it's about.
Okay. All right. So speaking of that, so would you say those are the steps that businesses should take to comply with these requirements?
I wouldn't say those are the steps. I would say that's the requirement itself. Like, what exactly is the crux of the requirement? The steps to comply, you can go to the FinCEN website. They have FAQs to actually, help guide you. If you want to take your time, have some time to read the requirements, to read the FAQs, you can do it yourself. I would have to say this: the deadline to comply depends on when your entity was formed or registered. That's a very important thing. So the deadline. So if your entity existed before, so for existing entities, these are entities that existed or formed or registered in the United States before January 1st of 2024, they have to submit their BOI reports by January 1st, 2025. So next up, we have 2024 entities. 2024 entities. These are entities that are formed or registered in the U.S. between January 1st, 2024 and December 31st, 2024. They have to submit their reports within 90 days of forming or registering the entity. So, for example, let's say you form an entity in a new LLC in New York on January 15th, 2024. That means you have until April 14th, 2024 to file the report. And let's say you form an entity next year. Let's say next year, 2025. So let's say your entity is formed or registered in the U.S. after January 1st, 2025. They're going to have 30 days to submit a report. So you see the amount of time sort of changes after this year. Also important to note, there are changes made within the information about the company or about the beneficial owners or the company applicants. You'll have to actually go ahead and submit information. Let's say you update information, like when those information changes, you have 30 days from the change to report those changes. And if you have an inaccurate report, you have 30 days from the date you become aware of the inaccuracy to correct information. And another important caveat, if your existing entity, again, you were formed before this year, January 1st, 2024, you don't have to report information about company advocates. So give you a copy. Yes.
All the things. I'm like, I tell you, Merlyne, this has been a long time since I wrote this many notes, and I'm all in. I'm loving it. Okay. And so what happens if you don't comply? So let's talk about the potential penalties.
Yeah. Okay. So this is important to say that this is a new law. They have the Department of Treasury has listed out potential penalties. They were saying that, if you provide false information or you fail to report complete information willingly or willfully, that it can result in fines up to $10,000 and up to 2 years in jail. So in essence, you basically want to make sure you comply because
Mm-hmm.
the penalties are severe.
I'm too cute for jail. I can't.
You don't want to go there.
Don't want to go.
No.
So, speaking of legal and some of the practical implications, one of the things you mentioned that was good for people to set some reminders, and I want to talk about any other practical strategies that business owners can implement to ensure that they're compliant with both the FTC Non-compete Rule and the Corporate Transparency Act.
Good question. I mean, I think the best thing you can do, particularly for the non-compete rule, is to engage legal counsel.
Right.
This stuff is complex. I'm not gonna lie. Yeah. It's super complex. And the amount of time it may take a business owner to understand what's happening and try to comply with it, it may take too much of their time because they could spend their time marketing and doing other things. Yeah. I say particularly for that is something that they want to engage an attorney for. For the CTA, the website, the FinCEN website has done a good job of compiling FAQs. And if you want to go through the website yourself and do the requirement, that's something you totally could do. Yeah.
Love that. So one of the things you mentioned, like the websites, and where can business owners go to access education resources to really stay up to date on regulatory changes?
That's tough because there are different agencies that control different things. That's a good question. I mean, I think that if a business wants to be kept abreast of these rules, I think setting a Google alert, a Google alert is a great way to be kept abreast of what's happening in general. I don't know if you could put FTC or just business or law. That's something you probably do.
Yes. So yeah, because this is very, as you said, it's very complex. And one of the things that you mentioned, of course, we know it's to seek legal counsel. So you are the expert here. You are the legal advisor. And I want to talk about the ways that your firm can assist businesses in understanding and complying with these regulations.
Yes. And so when my clients engage me, a important part of what I do is business structure. So business structure means forming entities, but it also means complying with the rules and regulations related to their entity. Because just because you have an LLC or corporation, if you're not following the rules and regulations related to that, you can still lose protection. People can still go after you personally, your personal assets. And so I remember in law school, one of the classes I took was called business associations. And you learn about these principles like, hey, if you're creating these entities, you're getting a huge bargain with the states in which they're formed, right? They're giving you limited liability. People can't go after you personally, your personal asset, in exchange for you doing certain things.
Right.
Like you having a corporation, you have to have your bylaws. You have to have at least one annual meeting. You have to have officers. You have to do those things. Even if it's only you, even if it's only one person, these are things you have to do because you run the risk of being sued personally should something go awry. And so that's like a huge part of my practice of educating business owners on these types of principles, making sure that they comply. And my job too is to be kept abreast of what's happening with the laws and regulations to make sure that people can't go after them personally. People can't do what's called pierce the corporate veil of protection. And so this particular, for the CTA, for the new law regarding that, that's one of those new things that, okay, like, hey, you have to comply with this because you run the risk of being sued personally if you don't comply.
Yeah. I love that you said that. That was just so much perspective. I just had an aha moment when you said how it's basically like you're creating these businesses and you're in partnership. If you do these things in exchange for this, that's your responsibility as a business owner. And I think that puts things into so much perspective.
Correct.
We have top tier on the Black to Business podcast. So let's talk about the future. Like, how can businesses stay proactive and adaptable in the face of regulatory changes?
Engaging a cloud counsel, perhaps, or like it's following the newspapers like Fortune or New York Times. Be kept abreast of what's happening in the laws. Yeah, unless you become a lawyer, you can become a lawyer as well. You can only become a business lawyer as well. Totally up to you.
You are hilarious.
It can be boring stuff. I mean, like, I don't know if I'm a business owner myself, right? Like, I know my zone of genius, right? My zone of genius is the law, right? Marketing and accounting. I hire someone out. I farm it out to someone else because it's not worth my time to learn those things. And my zone of genius is to providing services.
Mm-hmm. Yeah.
That being said, I think for me, a important reason that I do what I do is like, I find that educating people is something that I really love to do. So to answer your question, I have a blog. I actually have a blog on my website where I provide information about things like this. I actually have a breakdown of this, the FTC Non-compete Rule. I have a breakdown of the Corporate Transparency Act. So if you want to just have a summary of what I just said, you go there and just basically go look at what I just said and just in writing. I'm a huge proponent that with knowledge that business owners become, number one, they become less risky, right? My job as a lawyer is to assess risk and to hedge it and ultimately reduce it. That's my goal. But I feel that with knowledge, it makes your business less risky, which in turn makes your business more valuable, right? You think about, your end strategy of, let's say you want to merge your company down the line, right? You want to actually sell your company. It is, if your company is risky and you're the person who's trying to purchase your company engages in due diligence and finds out that there's no contract for this, you claim you have ownership of these IP rights, but you don't, it's going to be much more costly to you because you may lose the value of your company. They may try to offer you a lower price because your company is not sort of operating in a way to make it less risky.
But that is so good. And we just had an accountant on the podcast. And one of the things we talked about is a lot of times knowing when to seek out these things, or of course, like our entrepreneurs that are listening, maybe in their early stages, and also the importance of this, but then also budgeting for these things. So what would you say to someone who's thinking, what people think, if they're thinking accounting, they're thinking expensive. Right. If they're thinking an attorney, that's expensive. So, could you kind of share how could people tackle that, or what would you say to them?
I'd say this, because I'm also a business owner as well, right? I made a mistake of not engaging an accountant when I needed to, pretty much when I started, and it cost me money. So that's the perspective I come from. In terms of hiring an attorney, it's up to you and your risk tolerance. Are you okay with paying money now or paying money later? I would say that my job is to think about the worst case scenario and to prepare people for that. It doesn't mean it's going to happen, but I've seen the case where it does happen, and the cost that a client expends after the proverbial blankets hit the fan, it is much more expensive had they engaged an attorney earlier. So, I think there are lots of resources out there. If you are a creative person, and make a certain amount of income, you are able to engage in volunteer organizations that can help you. There are many organizations that provide work pro bono, depending on what type of business you have. I know I work in New York, and that there are volunteer organizations for the arts. And there are also freelancer organizations that provide legal access to many types of businesses. So I'd say look for if cost is a concern, you may want to look into that. The caveat that is that you're going to have to spend more time, right? They can't fix your entire problem as fast as someone you hired them directly. And I'd say the things I've seen in my 12 years of practice, I thought about, all right, it was possible. And in law school, how they teach you is through cases. What does that mean? That means things went wrong, right? If it's getting to case law, that means they didn't settle. There's no summary judgment. It went far, So you're taught as a lawyer by look at the worst case scenario from the beginning. And so I don't want to say that that's the way I think, but that's literally what you're paying a lawyer to do. You're paying them to think about the worst case scenario, because it's your job to be positive. It's your job to think about, marketing and how you're going to do all these positive things. And it's my job to say, hey, here's what could happen. Here's what we could do to prevent it from happening, or reducing or hedging the risk if it does happen. So it depends. It depends on your risk appetite. Got
it. Yep. And so for you, somebody is listening and they're like, okay, I want to work with Merlyne. What are some of the ways that I can start to begin to work with you, or what is your process when working with clients?
Yeah, you can contact me, contact the firm at info@jllaw.net. So JLLAW.net, and send us an email and we'll take it from there. You can also call us. Our website is jllaw.net. The process is we have a call, right? Because it's I feel in general, it's like dating. We have to make sure we're a good fit, right? We have to make sure we're a good fit. You may hear me now in like during this podcast episode. It's like, yeah, she's awesome. I want to hire her. Let's go. I still have to vet you. No shade. No shade. For the most part, everyone's fine. But like it's also a cost, right? I am a experienced lawyer. I went to some good schools. I went to Duke for law school, NYU for undergrad. I'm licensed in 2 states, New York and California. California being one of the most difficult states to get licensed into. So, I know about the value I can provide. We just have to make sure that we are a good fit for one another. But I am always down to help people. This is my passion. I'm here for it.
Love that. And speaking of more about you and your passion, so one of the things you mentioned in the beginning is how you forged your own path.
Correct.
Looking back, what's been the best risk that you've taken in your journey?
That's a good question. I would say it is starting because, full disclosure, I went to law school with the intention. I used to be a dancer. I was a semi-professional dancer when I worked as a paralegal full-time before going to law school. So my goal was to ultimately go in-house to work for Alvin Ailey. Like, that was the reason I went to law school. I was like, I'm going to go study IP, work for a big firm, pay down my debt, and then go work in-house for Alvin Ailey. That was the reason I went to law school, and that was the goal. And I think it was going outside my comfort zone because it doesn't make any sense why a lawyer would start their business the way I did, right? Lawyers, we're risk averse. We are very risk averse. And starting a business is risky. So I think the riskiest thing I did was starting my business without having any really experience in the areas of law that I practiced or any business experience. I figured it out along the way. I think I had to have faith in myself and think that, hey, I'm smart. I'll figure it out.
Yeah.
Or engage people who can help me. So I'd say the riskiest thing I did was starting a business.
That's good. And so many people could probably relate to that. And speaking of that, just for somebody who's listening that might be in their first year of business, what advice would you give them?
Oh, that's a good question. You're asking some amazing questions, Monique.
Thank you.
I'd say talk to an accountant, talk to an attorney, business attorney. Even if you don't hire them, they can give you knowledge. Just talk to those people. Don't worry so much about your logo, your branding, because you can always rebrand.
Right.
Keep your overhead as low as possible when you're first starting out.
That's good stuff.
What else can I say? Yeah, I mean, if you can start your business on the side, that'd be amazing. I did. I started my business on the side, my law firm on the side. I recommend doing that because you still have the security while you're entering your entrepreneurial journey.
That is good. Can I say that's solid advice? That's solid advice.
Thank you. Thank you very much. I appreciate that.
Yes. And then for you, as you are managing, are there any tools or resources that have helped you maybe stay organized? Books?
That's a good question. Because I was a paralegal at a big law firm in New York prior to going to law school. And I say that was the best thing I could have done for running a business because it made me be aware that systems and organization are very, very important for operation of any business. And so the principles I learned during that particular job, I use in law school, I use to this day in terms of organization. But in terms of the tools that I use that I love, I'm a huge fan of Google Workspace. I love Google. I'd say Dropbox is another thing that I like as well. What else did I use that I love? I have a virtual receptionist that I do love now that I didn't have one when I first started, but I have that I love. Having a newsletter, having a way to contact potential clients and get emails, paramount. Paramount in terms of my marketing strategy. It's my favorite way to market myself. And so I'd say that. Those are probably some of my favorite things.
Good stuff. And I'm definitely going to write those down and put them in the show notes. And my final question is, what does it mean to you to be Black in business?
What does it mean to be Black in business? To me, as a Black attorney, right? I think I just read a stat recently that there are only, of the lawyers in the United States, only 5% of them are Black. This is despite the fact that there are 13% or African Americans represent 30% of the U.S. population. It is to know that you are in a minority, but to use that as superpower and not worry about it. And I don't know if that makes any sense. Like, you're unique. You might as well just live in your uniqueness and make it your superpower.
Love that. Merlyne, you have been on fire today. We got through a lot in such a short amount of time. I tell you.
I talk really fast. That's why. I talk a mile a minute. That's why. Probably people who listen now, they probably slow me down like to 0.5 or 0.75 to hear me out.
No, it was perfect. It was really great. And this is like a true masterclass in a podcast. Thank you so much for doing the work that you are doing, betting on yourself and pouring into the Black to Business community. Thank you so much for being on the show. Thank
you again, Monique, for having me. I really appreciate it.
All right. And that brings us to the end of another truly, truly, truly impactful episode of the Black to Business podcast. Such a huge thanks to Merlyne for really dropping so much knowledge today. And we dug into some pretty big topics like the FTC Non-compete Rule and the Corporate Transparency Act and how these changes could affect your business. We sincerely hope you found the conversation helpful and that you're feeling a little bit more equipped to protect your assets and brands. So thank you for sticking with us and for being such an integral part of the Black to Business family. If you want to dive deeper into the resources that we mentioned and learn more about Merlyne, head over to blacktobusiness.com/209. And I get that today's episode was packed with so much information, and that's exactly why it was so valuable, because it was one of those masterclass episodes, and I recommend you come back again and again. And for me, this truly, truly, truly reflects why we do what we do, to educate and to inform our incredible audience members like you. Throughout this conversation, it was such a beautiful reminder of our mission and just to highlight the work that many in our community are doing, like Merlyne, true legacy builders, change makers who are forging their own paths and still educating others in the process. So I want to thank you so much for tuning in and for being here with us. Your support means the world to us. And I will see you back here next week. And in the meantime, keep building and keep pushing the culture forward. Later.